pleasure to moderate such a timely issue as financial crime has ramifications that are of huge interest to several areas of law and policy. So without further ado, I wanted to introduce our speaker for today, Dr. Dominic Thomas-James from the University of Cambridge. So Dr. Thomas-James became a fellow at Yale University's Global Justice Program back in 2020, and he earned his PhD from Queen's College, University of Cambridge, where he also teaches on the Justice and Development Program at the Department of Politics and International Studies. Dr. Thomas-James has a stellar curriculum. So I wanted to highlight from among his several accomplishments that he is also a secretariat member of the International Symposium on Economic Crime at Jesus College, Cambridge. And he's also regularly invited to speak at international conferences, having recently served as an expert speaker at regional consultative forums convened by the Intergovernmental Action Group Against Money Laundering in West Africa. Dr. Thomas-James teaches law and international development at various universities, including, as I mentioned, the University of Cambridge, University of Lincoln, and BPP University in London. And finally, his written work has been published in various peer-reviewed journals. So I am personally very excited to hear from Dr. Thomas-James on recent legislative efforts in the UK to fight economic crime. And just before I give the floor to Dr. Thomas-James, I wanted to mention that we have been facing a couple of busy years when it comes to financial crime regulation. And the UK is certainly quite busy in that front too. So for instance, in just this year in 2023, we have several initiatives, namely the first one is probably the most discussed, which is the UK Economic Crime and Corporate Transparency Bill. Second, potential change to the compensation for victims of international bribery, which I think it's quite interesting development. Third, the new UK corporate offence of failure to prevent fraud. And finally, last but not least, as I am myself an ESG lawyer in Brazil and in New York, expanding legal requirements to include ESG within due diligence and third-party risk management. So these are all very interesting developments. We are all, I'm sure, eager to hear from Dominic Thomas-James. So Dominic, the floor is yours.
Alessandra, thank you very much for that very nice introduction. It's very good to meet you. And Thomas, thank you as well for the invitation to be with you all today. It's a great pleasure. I think this is my third Global Justice Conference, so it's really excellent to be with you all. As Alessandra pointed to, one of the activities that I spend considerable time involved with is the annual International Symposium on Economic Crime at the University of Cambridge at Jesus College. And interestingly, this year took as its theme for the 40th symposium the subject of integrity. And it's something that I will sort of round out my remarks by addressing some thoughts on this moving forward, sort of looking into the future within our field of economic crime and what indeed integrity means, and indeed whether we can think about this very important area in somewhat different ways. So my research focus within the broader economic crime and financial regulation field is really interested in the suitability or otherwise of internationally advocated standards in this area, including those relating to money laundering, terrorism financing, bribery, commercial misconduct, and tax and financial integrity related issues. I have a particular research interest in the offshore world, having brought a book out a little while ago on offshore financial centers and the law, and also how financial center jurisdictions, particularly those small jurisdictions, respond to ever-changing international standards in this area. Within the broad subject matter of this session, I wish to share today with you some perspectives from the UK in terms of current and recent initiatives designed to really prevent and try to disrupt economically motivated crime. And I'm going to focus on three areas. The first being the failure to prevent fraud on the part of corporates offence. And that, of course, builds on areas we're familiar with in the UK in relation to bribery and indeed in relation to the facilitation of tax evasion. So this failure to prevent fraud offence, which is very much new law in this jurisdiction. The second being another recent development called unexplained wealth orders. And these, of course, can be found in the Criminal Finances Act 2017. And I say they're recent, even though, of course, we're some years on now, but developments are still somewhat protracted in this area. But nonetheless, I'll hope to provide you and furnish you with some information as to these particular orders, how useful they can or might be, and some of the challenges that sort of stand out. The third issue I'm going to touch upon is beneficial ownership transparency. Some very interesting jurisprudence coming out of Europe currently, really throwing a massive spanner in the works in terms of transparency efforts in this area. So we can discuss that as well. And as I alluded to, I'll also share some thoughts on integrity moving forwards. I know that many participating in this conference and indeed the Global Justice Programme and its associated organisations are particularly interested in the subject of integrity. So perhaps that will provide some food for thought as well. So the first point I wish to focus on is the failure to prevent fraud legislation, recently approved just this week in the UK Parliament, and therefore very much new law. Those researching or practicing in the field will be familiar with the ever-expanding scope of failure to prevent offences. Corporate criminal liability for facilitative conduct, really born from lack of systems or indeed the robustness of those systems, is an increasingly visible prevention measure. However, it's not without criticism of over-regulation and indeed concerns of proportionality. These sorts of offences place criminal liability on corporates and other organisations, and typically financial penalties such as fines, if some sort of misconduct took place for which reasonable prevention measures or systems ought to have been in place to catch and prevent. Now, in the UK, we've seen these offences for some time. For example, we have the failure to prevent bribery offence under the Bribery Act of 2010, and also the failure to prevent tax evasion offence on the part of corporates as per the Criminal Finances Act 2017. And the new legislation in the UK, which is termed the Economic Crime and Corporate Transparency Act, expands the failure to prevent offences, those we're familiar with, into the area of fraud prevention. Now, the UK Parliament tried through the bill stage to expand this even further into the area of money laundering, so a failure to prevent money laundering offence. Now, this, despite considerable advocacy by some very prominent figures in the UK on this subject, and indeed distinguished parliamentarians who've practiced in this area for many years, advocated for this, but the House of Commons disagreed with this sort of expansion to include a money laundering failure to prevent offence on the basis of over-regulation or indeed duplicate regulation. And they indicated that the law already makes sufficient provision in relation to the prevention of money laundering. Now, by this, of course, we obviously have numerous laws, standards and regulations. The money laundering regulations, of course, spring to mind, that affect, of course, the financial regulated sector, but also the designated non-financial businesses and professions sector as well. Many, of course, of those organisations' activities were hitherto under or indeed unregulated, and therefore having that thrown into the mix and the toolkit, of course, has been a very significant change in the global and indeed the domestic anti-money laundering framework in recent years. So this expansion to include that was voted against on the basis of duplicate regulation in that sense. Now, Under the failure to prevent fraud framework, an offence must have been committed by an organisation's employee or agent to the organisation's benefit or to that of another to which the organisation provides services, even if the organisation and its senior officers had no constructive knowledge, direction, involvement, or anything in the conduct. So the type of offence under this legislation includes fraud by false representation, abuse of position, and failing to disclose information as per the offences under the Fraud Act, but also various offences under the Theft Act as well. Now, a cautionary approach of sort of sticking to fraud and not extending this offence to include money laundering, I think demonstrates the divergence of views in what is a very contentious area. For example, in 2022, an options paper published by the UK's Law Commission considered this expansion and eschewed it heading towards a broad failure to prevent economic crime offence, pointing to the compliance burden and the fact that it would overlap with other frameworks already in place, particularly those aforesaid ones relating to tax evasion facilitation and failure to prevent bribery. Now, failure to prevent laws essentially target corporate compliance programs, and it implies not only the need to enact policies, but also to disseminate them widely enough, thereby obviating the risk of willful blindness on the part of corporates. It brings their role as facilitators of misconduct, rather than simply viewing them as victims without knowledge, very much into the fore. And this is important, I think, given that the laws recast the directing mind doctrine and don't require knowledge of senior officers of the company to be shown, despite, of course, something that something as serious as fraud in a criminal context has always required dishonesty to be proven in the criminal setting. Proportionality in this sense has always been a concern, yet for larger organisations caught by this legislation, they will likely, I would suggest, go to great lengths in order to implement reasonable prevention measures for fraud by engaging lawyers and compliance experts to draft programmes and to assist in the implementation of such initiatives. Notwithstanding the complexity of fraud and the different manifestations thereof, it's likely that many organisations which fall under the purview of this Act, I believe, will be likely already very familiar with the kinds of requirements needed to effectively implement failure to prevent measures, as indeed may have been their experience already to date in other areas, namely bribery and tax evasion. In other words, to comply with the new law in this area, they may simply need to expand their toolkit to cover the new types of misconduct which this law focuses on. Now, without wishing to simplify things, it may be the case that these new offences become technical add-ons rather than adding anything particularly substantive. Now, for those with significant resources and technical capacity, it seems that achieving these things will be somewhat rather straightforward to obviate potential liability. And I envision prosecutors encountering challenges when trying to advance that standards were not reasonable or were absent in a given case. A reasonable question that needs to be asked, and indeed that warrants further consideration, is whether such measures will actually stop fraud from happening, or are they simply measures that place fraud further under the corporate governance spotlight, thereby, of course, serving an awareness-raising function and a general deterrent function. The question on whether they have any capability of preventing crime is, I think, a rather more complex issue than the ostensibly more straightforward task of devising these standards in the first place and implementing reasonable prevention measures into one's compliance function. Now, from a criminal justice standpoint, one must consider deterrence and precisely who is deterred from doing what. If corporations face criminal liability, such as an unlimited fine for not having these measures in place to prevent fraud, then presumably the criminal law's core deterrent function is met, and it has the effect of targeting corporate governance and indeed, at its aim, cultural overhaul. In other words, in an Austinian sense, an organisation is deterred from a threat of criminal sanction for non-compliance. And this would be an organisation unable to advance a reasonable preventions measures defence to a criminal charge under this legislation. Now, taking aim at facilitative conduct in the fight against illicit enrichment has been, of course, a long-standing hallmark of the global anti-money laundering and counter-terrorism financing framework. Will this particular initiative have any meaningful impact on the prospect and indeed the prospect of preventing the crime itself? like an insurer stipulating that its customers must retain some form of burglar alarm in order to receive insurance cover in the event of a robbery, reasonable prevention measures may well be enough to get cover, or indeed in this context, advance a defence in a failure to prevent charge. However, it is a quite separate issue then if the conduct occurs despite such measures. By their definition, such measures aim to prevent the facilitative criminality. If the measures are in place and considered indeed by a court to be reasonable, then if the thing still happens despite this, the organisation may well have a defence and therefore avoid liability. So the proposed disruptive effect, I would urge, needs further consideration. The second point I wish to explore is the relatively recent tool in the UK armoury to tackle illicit enrichment, and that is unexplained wealth orders, or UWOs, as you may have come across them termed as. And these, as I said earlier, are found under the UK Criminal Finances Act 2017. In a compendium I co-authored with Professor Jonathan Fisher, KC, and others on this issue, was indeed cited during the bill stage in the UK Parliament. And I have to say my initial optimism has rather faded. I've also authored a more recent chapter on this in Ryder's research agenda text on organised crime, which looks at how this power operates in the context of investigations that carry an offshore element within, whether it's corporate structures, whether it's within asset tracing or whatever. And I'd be very happy to share links to those papers with colleagues should anyone be interested in that following this session. Now, the issues of illicit enrichment really depend, of course, on where you look today. They can, of course, include measures under the criminal law, the civil law, increasingly under the regulatory frameworks. But they all, of course, are united by raising fundamental questions, including the status and role of politically exposed persons, or PEPs, as they're otherwise known, issues indeed as to legal safeguards, including the presumption of innocence, as well as issues relating to reverse burden shifting. So what are unexplained wealth orders? Well, they are civil powers within the investigator's toolkit, and the provisions found at Section 1 of the Criminal Finances Act. And they are orders which can be sought from the High Court in the UK in respect of someone who is either a politically exposed person or someone involved in serious crime, or indeed, and that's the important bit here, it can include some close associates or family members of those individuals. Now, the order places a rebuttable presumption on the asset holder that the asset was funded illicitly by ill-gotten gains, and that asset must be valued at £50,000 or more, so about $70,000. Now, the High Court must, in this instance, be satisfied that there are reasonable grounds for suspecting that the known sources of the respondent's lawfully obtained income would have been insufficient for the purpose of enabling them to obtain the property. So let's take an example. Imagine you're a public official and that official discloses publicly that he earns £60,000 per annum, so about sort of 80, 90, 100,000, depending on the exchange, in dollars. Yet he's seen driving around in a sports car valued at £1 million and taking vacations on private jets, and is discovered to be living in a £20 million townhouse in central London. Now, this sort of thing may give rise to such a suspicion. Now, where there may be a perfectly legitimate explanation, for example, that the public official in question may have recently come into a large inheritance, what does the respondent have to do? Well, the order creates a rebuttable presumption that the assets, or the asset that happens to be under suspicion, was funded illicitly, to which the respondent can obviate by providing a legitimate explanation, a fact-based explanation, which may require him to answer various questions prescribed under the order, provide documents or other evidence depending on what the order requires. Now, the order requires the respondent to reply in a given time frame, and the authorities then investigating have up to 60 days to make a determination based on the information that's provided. That can be extended on application to a further 126 days. Now, once the order is obtained, it may be accompanied then by an interim freezing order, which prohibits the respondent from dealing with the assets for obvious reasons, dissipation or whatever. Now, if the respondent fails to comply or indeed responds without reasonable excuse, fails to respond without reasonable excuse, then the property becomes what's known as presumed recoverable property, and a claim can therefore be made to the court to confiscate the proceeds, the property as proceeds of crime, via what's known as a civil recovery order. So the unexplained wealth order process, if you like, as an investigative tool, aims to make it easier to arrive at that destination. Now, statements made in response to an unexplained wealth order cannot be used in evidence in criminal cases, generally speaking, as indeed the response essentially compels from the respondent to answer the questions, otherwise lose their property. Thus, the right to silence that one would typically have in a criminal case does not exist here. If the respondent provides false information, then that can give rise to criminal liability with a maximum period of up to 2 years in prison. Now, we can find the sort of backdrop to the unexplained wealth order provisions in the UK somewhat in the United Nations Convention Against Corruption, of which Article 20 advocates for criminalising illicit enrichment, which is defined as a significant increase of the assets of a public official that they cannot reasonably explain in relation to their known lawful income or assets. Now, the convention obviously contains mandatory and non-mandatory provisions, and Article 20 being a non-mandatory, countries are therefore at liberty to decide how and to what extent this should be implemented or otherwise. This is where the civil framework's been opted by various countries, including the UK, which appears to at least go some way in meeting the spirit of the recommendation, in that it targets, or it seeks to target, the illicit wealth of politically exposed persons, but of course goes further to include those involved in serious crime and their family members and close associates. Now, one of the concerns about this framework is really the risks regarding reverse burden shifting. In other words, tell me where you got the money from, and if you can't do that, then we'll take the property from you, even if you've not been charged or convicted of a criminal offence. Of course, reverse burden shifting is seldom seen in criminal cases, save for if you make some sort of affirmative defence, or defence, for example, of self-defence, or if you're charged of murder, responding through a defence of diminished responsibility due to mental incapacity. And at that point, of course, someone raising that defence, of course, has to put forward evidence to buttress that point. But of course, in the civil context, we do see reverse burden shifting more frequently. Colleagues, you may be forgiven for thinking that this unexplained wealth order provision sounds quite straightforward. And frankly, from a technical and a legislative standpoint, it does sound straightforward. However, as experience is showing us, it is anything but. And the UK's frankly underwhelming record in this area can be very much contrasted with the grand plans circa 2017. A high-profile example demonstrating the challenges with unexplained wealth orders in the UK was the case of NCA and Baker in 2020. And in a nutshell, I won't go into the depths of the case with you, but in a nutshell, it concerned 3 unexplained wealth orders that were granted by the High Court in regards to property in London worth around £80 million. An important element of the National Crime Agency, the body that was in charge of investigating and pursuing this unexplained wealth order, a crucial element of their case rested on complex financial ownership structures offshore. Indeed, this came at a time where there was a whole host of reignited interest in this area, and particularly the offshore world, due to these major data breaches emanating out of Panama and Bermuda. What was interesting about this judgment in the Baker unexplained wealth order case was the investigative weight placed on the simple use of offshore structures, which were alleged to have purportedly transferred and held interests in the property in question. Now, while these were complex structures, they were not held to have met the test of suspicion, giving rise to a flaw in the investigator's case, and that was subject to strong judicial criticism in the High Court. In judgment, the court averred the need to exercise caution when examining complexity in ownership structures and property holding entities, as indeed grounds for suspicion. And Justice Lang averred that the principle of using complex offshore structures cannot give rise to suspicion of wrongdoing in and of themselves. Of course, the latter bit being important in the investigative context. And in judgment, Lang said that the use of complex offshore structures, corporate structures or trusts is not, and I quote, without more, a ground for believing that they have been set up or are being used for wrongful purposes such as money laundering. And the judge went on to say that there are lawful reasons, whether it's privacy, security, tax mitigation, why very wealthy people invest their capital in complex offshore structures or trusts. And then went on to say, of course, such structures may also be used to disguise money laundering, but there needs to be some additional evidential basis for such a belief going beyond the complex structures used. Now, the Baker case clearly serves a broader warning when considering the issues of offshore, and indeed clearly presented an issue not only to the fundamental challenge of addressing the evidential hurdles required for granting an unexplained wealth order, and indeed whether the property can be consequently in the line of fire for confiscation, but also the broader issue about investigative efforts in examining offshore structures themselves. There was another example where the National Crime Agency had some in this regard relating to Mr. Hussain, and the National Crime Agency achieved a settlement with this subject that saw the subject relinquish ownership of numerous properties totaling around £10 million in total. And that was on the basis of suspicion links with serious crime. The receiver complied with the order, but the according to the NCA, gave rise to greater suspicion, providing the authority with leverage in this regard. Now, we can contrast that case very much with the Baker one, which concerned overseas politically exposed persons compared to, of course, domestic links to serious crime, and therefore perhaps provides food for thought maybe on how these cases may see greater likelihoods of success within the jurisdiction. Of course, in that one, there'd been no conviction, but a settlement in a different avenue of the law. And this brings me to question whether this function serves as a deterrent. Settled justice really appears to be seen in more and more cases of economic crime these days, whether it's unexplained wealth orders, deferred prosecution agreements, or indeed other regulatory penalties. And one has to consider, if one is involved or closely connected to crime, whether one simply forfeits the property, wipes the slate clean, and starts from scratch. And in the context of a civil penalty, starting again from scratch without the comparative disadvantage of a criminal record. Now, buttressing, of course, this conjecture, the UK government in its recent review of unexplained wealth orders in a policy paper entitled Unexplained Wealth Order Reforms, and it was from March last year, claimed that given the value, and I quote, even a single unexplained wealth order will have high impact. One has to really query, I would suggest, the seriousness of purpose of this endeavour if across all the statutory bodies which are empowered to investigate and obtain unexplained wealth orders, if all hope appears to be hung on a single one. Colleagues, one has to consider whether these orders and their underwhelming use to date actually provides any deterrent to illicit activity. As I said, as I opened my remarks in relation to unexplained wealth orders, I have to say I'm not as optimistic as I once was, notwithstanding how straightforward they all sound. After all, they were meant to make things easier relating to illicit finance, yet their efforts as projected are still seemingly unrealized. Now, the third point I wish to make relates to ultimate beneficial ownership transparency relating to legal entities. Now, this area is particularly controversial and has very much become a standalone topic in recent years since the Panama and Paradise Papers data breaches. And in the UK, we have a public register of beneficial ownership information that's existed since 2016. A public version of that existed for some time before. And there we can see a whole raft of information for free about UK companies, all 4 million of them, including the names and details of company officers, the registered address, certificates of incorporation, registers of charges, and importantly, since 2016, information on ultimate beneficial owners. In other words, as the UK frames it, the persons with significant control register. Now, this means that anyone who owns or controls more than 25% of the voting rights of the organisation has to disclose information about beneficial ownership. Now, I addressed last year's Global Justice Conference on this theme, so I don't propose to repeat my remarks, but a recent piece of jurisprudence from the Court of Justice of the European Union has put at a very powerful and indeed influential level somewhat the brakes on transparency in this area in its complete sense. I won't go into great detail about the case itself, but if you'd like to have a look at it, it's called W.M. and Sovim SA, the Luxembourg Business Registers. By way of background to this development, the EU's fourth anti-money laundering directive required member countries to implement domestic laws requiring entities to hold information about their ultimate beneficial owners, and indeed to establish a central register in this regard. Such information would be available then to anybody with a legitimate interest. Now, traditionally speaking, that means law enforcement. Yet, the fifth anti-money laundering directive amended this provision and required member states to allow access to any member of the general public for these registers. In a nutshell, the court held that unfettered public access to ultimate beneficial ownership information was invalid and that it could constitute a breach of Article 7 and Article 8 of the Charter of Fundamental Rights of the European Union, specifically the rights to respect for private life and the protection of personal data. The UK last year, in a white paper reform to its companies register, self-labeled Companies House, which is the authority that deals with maintaining and running the register of companies in the UK, as, and I quote, a passive recipient of data. Now, a system which harbours rubbish in, rubbish out, if I can be bold enough to suggest that, will continue to overshadow transparency arguments and certainly strengthen arguments about proportionality and data protection, as we're seeing at the EU level. Therefore, one of the thoughts I shall leave you with is about integrity of systems and the need for a renewed focus on integrity and data and its collection. This needs, particularly with the increasing concerns about technology in this area, as well as technology being a particularly useful tool, it needs to be a priority. This issue is quite separate from the considerable integrity arguments upon which such legislation is often based. In other words, transparency equals integrity. And transparency can surely only really be a valuable investigative tool, and indeed, therefore, a deterrent if the information being scrutinized is valuable information. Tipping off bad actors that their information is about to become public will only, if indeed it is contained in their name in the first place, will only incentivize them to look to restructure to darker jurisdictions. As we know, colleagues, there are plenty. The new Economic Crime and Corporate Transparency Act does aim in the UK to better utilize verification technology, something that's been criticized considerably in this area. After all, most transparency arguments presuppose an innate value in the accuracy of the data. Of course, versus data that's closed. You know, if the data itself is open versus data that's closed, then that, of course, is the argument that underpins shining a light on things. Yet, just because something was in the dark yesterday and is indeed in the light today does not necessarily mean that it will be valuable data. The Panama Papers, for example, had the element of surprise at its heart, and it was really upon that which all the exposures and the relative successes that they had in that regard were based. However, making registers public moving forwards is not an overnight affair, as we know, and it's now achieving, trying to achieve standardization on the correct standard for the storage, the maintenance, and the accessibility of this information seems even further away and more controversial than it was before these data breaches, based, of course, on this jurisprudence coming out of Europe. Interestingly, the UK's Human Rights Act is, of course, modelled on the European Convention. And of course, while the UK now not having to be bound by jurisprudence from Europe, given Brexit, one would think that, one would still, at least keep abreast of these sorts of developments. And what is particularly interesting is that the UK's network of British overseas territory jurisdictions, so jurisdictions like Bermuda, the Cayman Islands, the British Virgin Islands, Anguilla, Turks and Caicos, Gibraltar, etc., they have to comply by the end of 2023 with implementation of public registers of beneficial ownership, else face having them imposed unilaterally via orders in council, which the UK does have the power to do and intervene with, notwithstanding the constitutional and the conventional challenges that this might otherwise pose. But of course, given what's happening at the European level, and after that decision in relation to the Luxembourg business registers case, many registers went off overnight, went offline overnight, of course, for fears of being in breach of convention rights based on that decision. So it is going to be particularly interesting to see what happens to this moving forwards. And finally, I wish to share a few thoughts on integrity in the economic crime field. And it's a subject we took as our theme for this year's annual symposium on economic crime, indeed a symposium in its 40th year at Jesus College at the University of Cambridge. Now, for anyone in the audience that does know me, you might know that I'm a sailor. Since boat propulsion by wind has existed, mariners have, of course, had to navigate the seas with a mix of rudimentary and sophisticated methods. Ancient mariners, for thousands of years, navigated the seas, observing landmarks if they were sailing coastally, close to shore, or indeed watching the sun, the moon, and the constellations if they were more offshore. And while mariners for centuries and decades awaited great inventions, the compass and then later GPS, stars and constellations, particularly for open sea voyages, were their navigation to calculate their position. Now, this complex navigation method required navigators to have acute knowledge of the different constellations' locations at different times of the year. Imagine that effort and those variables in the context of stormy or overcast conditions while at sea. This example, I think, can be much applied to the subject and notion of integrity when it comes to economic crime efforts. When we think of integrity, we're often told of moral compass imagery. I suggest that the idea of the celestial method of navigation, rather than the more familiar compass method of navigation, is indeed more closely aligned to the idea of integrity itself. When the compass fails a sailor, or one is waiting for such an invention in the first place, it's back to landmarks, it's back to the constellations to achieve any true sense of direction. Whether it's framed as an Aristotelian ethic or a moral or intellectual virtue, integrity requires us to act in ways consistent with this metaphor. In other words, we're living in a world of huge oversight, yet no matter how many regulations or rules are put in place, and those that we're of course all working on to assist us in both promoting integrity and implementing that into our systems, cases constantly remind us that there cannot be limitless supervision in a given setting. And this is why there are proportionality concerns about over-regulation and duplicate regulation in areas like failure to prevent fraud and indeed the overburden of compliance functions. The nature of being a professional, whether that's a lawyer, an academic, a regulatory official, or a law enforcement officer, it requires us to use our better judgment when no one is looking, in line, of course, with professional codes of ethics and codes of conduct, to act with integrity in our professional dealings. Indeed, and I'm also speaking now as a barrister, this goes further, to act even in ways in one's professional life, to act in a way which would not bring the profession into disrepute. That's there in our professional code of conduct. So like constellations to the mariner, integrity should therefore guide us omnisciently in our dealings and in our projects, rather than something that's simply incorporated and resigned to a rule book. For years, virtue ethicists have grappled with this notion of integrity, and whether it might actually be redundant in that the role integrity plays is perhaps already covered by other virtues and values. Many examples spring to mind, such as acting as a fiduciary under the common law obligations of honesty, acting dutifully in good faith and with trust and confidence. Isn't this precisely what we think of when we think of acting with integrity? Now, for a subject like integrity, which seems easy to identify, how is it that even in the most developed of countries whose systems of governance and democracy are revered, that it can still be lacking and therefore lead to the various political, economic and social uncertainties that we sadly still contend with? There is, of course, a risk of creating regulation in this area without result. And by this, I mean a series of laws or indeed internationally accepted standards that are underpinned by the notion of integrity, but do not place as much emphasis on the integrity of the system in the first place that will administer or enforce the same. A cardinal example, as I've mentioned in this talk today, are the calls for public and transparent registers of ultimate beneficial ownership relating to legal entities. Despite the recent jurisprudence at the EU level, holding that public accessibility, of course, potentially infringes upon the rights to privacy and data protection, which are, of course, Charter Convention rights, transparency still appears to be the direction of travel in many jurisdictions, including the UK, and indeed, as I've said, impending in the context of the UK overseas territories jurisdictions. So trying to come up with an international approach is, of course, becoming increasingly challenging. The problem, of course, is that with systems that seem to have forgotten about the need for integrity is really how those systems are prioritized moving forwards, while we might already think that integrity is a given. That the idea of bad data, for example, and there are numerous instances of the UK's own public register, continuing to display company information that is so clearly false or erroneous. An example that springs to mind that I saw a few days ago was a company that had set up as a limited liability company with a paid up share capital, bearing in mind you need £1 to set up a company limited in that sense in the UK, represented that it had a paid up share capital of something like 287 billion. Obviously, you know, amusing in its errors or whatever it might be, but you know, it does demonstrate that, you know, a greater grip needs to be on the integrity of the systems so that these erroneous entries cannot be made, and importantly, once they are made, if they have slipped through the net, that they can be removed easily. And that's where some of the reforms are headed in that direction with the recent legislation that I've spoken about. Colleagues, like the constellations and horizons, moon and the sun for the sailor, integrity needs to exist omnisciently. Unfortunately, I would suggest that it's either taken as given, which in our field is dangerously complacent, or it's simply not even existing there in the first place. And it may be that in talking about this and its role in conferences and forums such as this, that we can be perhaps a bit closer to achieving it. I hope that these insights from the UK and some of the areas that I'm interested in are of particular interest to you. I'd be very willing to take some questions. And like I said, I'm very happy through the organisers to circulate some of those papers I referred to in my remarks today after this session. Thank you very much for your attention, and I look forward to any interactions or comments you might have.
Thank you, Dominic, for this excellent overview of UK regulatory initiatives with regard to financial crime. It's really fascinating to observe how dynamic the regulatory environment has been in the UK in this regard in the past couple of years. Before we take questions from the audience, and I suppose Thomas would have questions for you as well, I wanted to kickstart our discussion with a couple of questions of mine. So the first question has to do with the relationship between environmental crime and economic crime. As background for this question, I wanted to mention that in the past year, I have been coordinating a study which is about to be published, but I think we can anticipate some of our findings, which pretty much determines that financial crime is deeply entangled with deforestation in the Amazon through it feeds into a complex web of environmental crimes and also human rights violations in the area. So one of the conclusions we came to is that we need further international cooperation if we want to actually cut the money pipeline that feeds into deforestation in the Amazon. So this could be done in several ways. So one of our recommendations is that we cooperate with our neighbors through, for instance, the Free for Amazonian Cooperation. And of course, we need, since we're talking financial capital flows, we definitely need global cooperation. So we have mentioned the need to cooperate more strongly with initiatives such as the GFI and GI Talk. So my first question is with regard to how do you see the relationship between human rights violations, environmental crime, and the financial flows that fit into these illegal activities through corruption, fraud, and money laundering. This question is actually twofold. The second thing that I'm actually curious to know your views about is the fact that we have been witnessing a flourishing of ESG regulations and also trade regulations with, so to speak, an extraterritorial component, in a way that risk management across global value chains also has been increasingly including mandatory environmental and human rights due diligence obligations. So for instance, we have initiatives such as in the EU, the CSDDD, which also goes hand in hand with CSRD. So I wanted to ask you whether you see some how the UK is likely to regulate similar issues. And finally, my second question has to do with the fact that this conference is about structural change. So I think it's really fascinating to consider that when we are talking about international bribery, that the victim countries are seldom compensated. So, and this, I think, became clear in a recent high-profile case, the Glencore case, which awarded 280 million pounds to African countries that were victims of international bribery between 2011 and 2016. So my reflection, it's perhaps it's rather a comment. It's more of a comment than a question, but should we be thinking about compensating victim countries of international bribery as a means to promote structural change?
Well, thank you very much, Alessandra, for those questions and indeed the background. I'll be interested to read that study when it's published. I have to say it's an area that falls outside of my particular research interests, but nonetheless, it's never far from my attention and indeed my thoughts, given the interplay with many of these points that you raise. A few things spring to mind and sort of stand out here. The first, I think, is particularly in relation to the sort of remit here of those tasked with administering standards that are going to help rather than hinder efforts in this regard. I think one thing that's really struck me, particularly in the area of anti-money laundering and counterterrorism financing, is how much is too much in terms of the different standards, the regulations, and so forth. Because of course, buy-in has to be paramount. That has to be the objective. And if there's not going to be buy-in, no matter how good the standard might be, how many experts are involved in its drafting, no matter how morally righteous the standard might be, it just is not going to get off the ground. And I'm seeing this in areas that I'm particularly interested in. The art market, it's a fascinating reality in the UK at the moment that if people trade in art that is over £8,000 in value, now that of course sounds like a considerable, a lot more than a standard poster one might buy from a department store. But likewise, is it really the area that is posing the most serious money laundering risks? And it's a similar thing that we see in the areas of property in the UK. New legislation that's aimed at carving out a beneficial ownership register for overseas entities that own property in the United Kingdom, having to provide their beneficial ownership information, else non-compliance having a fine, and that fine can be up to sort of £2,000 a day. When one considers that might be a considerable fine for someone that owns a £200,000 studio apartment somewhere, in the context of the 20-30 million pound townhouses, that is, I think, more where the legislators' imagination's lying on this, is just adding on another fee earner, frankly, for the price of anonymity, a very small price to pay in that context. So I think it's realizing about buy-in, and I think in relation to what you're saying, I think international organizations are, and we've seen this with all the criticism of greenwashing and so forth, international organizations and institutions have to be alive to the fact that if the standards keep changing, and if of course, as our understanding of things advances, then certain jurisdictions and regions around the world are going to be left behind. Because while they're trying to comply in earnest with various ESG standards that have been obviously advocated and enacted at the international or even the supranational levels, the next thing you know, they've got compliance with an outdated rulebook, and we're seeing this in respect to many small jurisdictions, ones that are technically classed as middle-income countries, but also have structural challenges, development issues, very perverse development issues that go right to the heart of their societies, finding that they're complying with things in earnest, but not really being able to keep up with the pace of change. And I mean, for whether this is right or wrong, it seems as though there have at least been some brakes applied to that in the UK context recently on the political side. Obviously the challenges that throws up are, and particularly how that relates to international efforts, is obviously going to be something that we're going to have to monitor closely moving forwards. In answer to your final point in terms of victim countries, I mean, there's obviously one of those very notable cases in Nigeria with restitution efforts, and as you say, in this case, that came out recently on this area. I think the reality is that the restitution efforts, they obviously cost an incredible amount of money because of the technical competency that is needed to get to that stage. But what I'm particularly interested in is thinking about how, once the money effectively is there, how it doesn't fall back into the dangerous cycle that the money was obviously in the first place. And if those efforts are not coupled with very serious international development work in the context of rule of law systems and anti-corruption programs, then obviously, again, there might be two competing forces there at bay. And of course, for the countries themselves, it's obviously vital for them to be able to get back on the course that they would have been on had they not had whatever it is, whether it's state capture, embezzlement, or whatever in the first instance. So you make a very real point in this respect, because when you think about victims of fraud, and I also serve as a consultant and director of publications to the International Chamber of Commerce FraudNet, which is an international lawyers organization that effectively specializes in fraud and asset recovery, and effectively chasing the spoils of fraud, as it were, to repatriate to victims. I know the international cooperation efforts that go on in relation to all of these types of issues. So it is, it's a really interesting area. I think we have to have it as a priority in our thinking, but we also have to couple that with a very vigorous and targeted response to those development related programs that I spoke of.
Thank you, Dominic. So I wouldn't expect the UK to offer a response to the EU's CSDD or CSRD, particularly given the recent U-turn in environmental and climate change policies, but I felt that I had to ask anyhow. And also with regard to bribery compensation, you make an excellent point in terms of how do we make sure that these resources, these financial resources, will not fall back into the hands of illegal activities that started this cycle. So one of the things that we have, one of our findings in the study that I mentioned, and I feel that this is something that can be extrapolated to the Global South, is the fact that it is sometimes really hard to distinguish legal and illegal activities when it comes to certain activities, particularly those concerning deforestation and rights of traditional people. So thank you for this. So I think we have another question. I can't see the name on the screen. So I'm sorry about my technical difficulties tonight, but
yeah. Dominic, thank you for your very nice presentation. I want to raise a question that I dealt with in my professional career, which deals with corporate fraud, corporate malfeasance, that I really struggled with. And I'll tell you the circumstances, and I would love to very much like to get your input as to how that could have been handled. I was partner in charge for PwC in Japan for almost 20 years. And one of the constant issues I had to deal with is that when companies would come to me with legal opinions saying that so-and-so tax position could be taken and that could result in significant tax savings, when they knew and I knew that it was totally well beyond the gray. And similarly, legal opinions that would imply that a payment that they were making was not considered bribery, but could be totally justified as a business expense. And a number of those situations, I found that the legal opinions, the companies would insist that I have a legal opinion about this, and why are you making a big deal about it? You know, the challenge was thrown to us as accounting firms when there's a legal opinion of this nature. And to my great surprise, a number of those legal opinions while I was in Japan and it dealt with Japanese tax law and Japanese practices were coming from London. Law firms in London were competing with each other to provide very aggressive tax advice to corporations operating in Asia Pacific. And this was advice that I clearly knew to be unacceptable. And I would find when I would turn down one legal opinion, another legal opinion from another law firm would embellish it further and come up with their reasoning for it. And the only way I could deal with it, to be honest, was to tell the client that if you wish to go with this opinion, I'm sorry, PwC would need to resign from the engagement. And that was the only deterrent that resulted in the client changing their mind. Because they could not afford for PwC to resign from Asia, from Japan, but not from New York or Europe and elsewhere. So unfortunately, we were constantly put under pressure by legal opinions that were fostering or encouraging or facilitating corporate fraud under the guise of, client confidentiality between a law firm and the company, so that the lawyers would pretend that they were really doing this in a very private manner to the company, and they had enough caveats in those legal opinions to excuse themselves should this escalate to a litigative circumstance. So can you guide me as to how this situation could have been handled? Because this is still a constant issue that we are dealing with as partners in accounting firms when we have legal opinions that take us to the edge of corporate malfeasance.
Thank you very much, Christian. There's a fascinating account there, and obviously a scary one. I mean, obviously, without obviously, I obviously speak as someone who is a barrister. We have particularly, there are always going to be, a few in the legal profession, a few bad apples. Of course, we all know that. That's of course why it's important for the profession to be subject, as it is increasingly the case, to advancing regulation in this area, not relying on outdated principles and outdated practices. I think the important thing really to sort of consider is effectively who the client is, and whose opinion effectively, or rather who can rely on the opinion or not. And I often find this the case where certain firms might say, well, we've got a barrister's opinion on something, and therefore you can trust what we're saying. And I mean, at the very sort of worst case scenario is that the eventual customer can't rely on what the firm is saying, because presumably the client of the barrister is the firm. So obviously there's always going to be that sort of difficulty, particularly when one is thinking on who can be relied upon. But of course, it does boil down to the fact that there always will be professionals who will sadly pander to what they think their client wants to hear. And you get that not just, in the areas you've described. I can think of it in cases I've been involved in at a much more sort of bread and butter level. You will always get professionals that will simply be saying what the client wants them to say. And therefore, sadly, they may well sort of say to their associates or their friends, well, you want to get that lawyer because he'll put up a good fight for you, even if the fight landed the person up in jail, or even if the person, landed them up with a fine. So, it is a concerning area. I think it certainly, it's other than the sort of lawyer shopping, if you like, I think your approach obviously sounded extreme in the sense that it was almost the last resort you had, which is obviously the problem, isn't it? The fact that was the last sort of course of action you could take, because you were finding the frequency of such opinions to be there and indeed to be problematic. And I think as well that does sort of as well boil down to our increasing understandings of the distinctions between tax evasion and the increasingly controversial tax avoidance, and of course certain practices that fall way outside of the spirit of what the legislators intended, but may indeed be within the letter. Well, we're seeing more and more of those sorts of schemes, at least in this jurisdiction, being targeted, being exposed, and therefore being shut down by the tax authorities. So it is a minefield. I think it does demonstrate the importance of regulation in the profession. But like I said, I don't really know what we can do about a few bad apples, and I hope it's not more than a few bad apples.
Well, I thank you for your remarks. I know our time is coming to a close. We get to the next session, but my follow-up to that simply would be that, is there any legislative action in the UK to rein in lawyers who have perhaps acquired a reputation of this nature, and it may be not unknown within the legal profession that there are lawyers who are doing this? Is there any way to penalize practices of this nature and hold these lawyers to account?
I mean, the thing that springs to mind, and I come across it just in both interactions and my research, are obviously the complaints made to the governing bodies that regulate the professions, and they then open their own investigations and disciplinaries and things like that. And of course, those processes, when they're obviously finalised, they're of course published. So there is, I think, a deterrent. I think, just to sort of finish on this point, I think that the advent of social media engagement on this means a lot more people are talking about it, and therefore a lot more are obviously going to be thinking about how the sort of the disciplinary efforts, if you like, all of a sudden start out very much more now in a public forum. I think there's a lot of danger to that as well, but I think a lot more people are talking about standards in the profession. That's the one thing that springs to mind. I mean, investigations, reporting people to the Solicitor Regulation Authority or the Bar Standards Board, that tends to be the process, at least that I'm aware of. Of course, it's lawyers tend not to be prime suspects in certain cases, for obvious reasons, perhaps, but it's there are of course ways in which lawyers do become joined as parties in proceedings, and indeed in the context of complaints made in disciplinaries as well. So yeah, I hope that's of some use.
Great, thank you.
Thank you, Christian.
So
Thomas?
I think in the interest of time, we need to wrap up. I think we're already slightly behind schedule. So I thank you again, Dominic, for this fascinating and highly enlightening presentation. I also thank the audience, and I thank Thomas for the possibility of being here this evening or this afternoon.